February 17th, 2026, the VA rolled out a new regulation that could have allowed many veterans to be rated based on how they function with medication instead of how severe their condition really is underneath the treatment. You heard that right. If you were being a good patient, taking your meds, managing your pain, controlling your symptoms, following your doctor's orders, the VA was moving toward a rule that could have used that improvement against you. They called it evaluative rating, impact of medication. A lot of veterans called it what it felt like, a direct threat to ratings they earned. 10 days later, the VA rescinded it. But here's what most veterans still need to understand. Even though that rule was pulled back, the danger is not completely gone because C&P exams can still focus only on how you look while treated, while medicated, while managed, and fail to document how severe your condition is without that treatment. If you are on medication for a service-connected condition, this video may be one of the most important updates you watch this year. I'm going to walk you through exactly what happened in February 2026, why veterans were so concerned, what the VA reversed, and what you need to do right now to make sure your rating is protected. Here's what we're covering: the regulation the VA tried to put in place, the legal cases that made this issue so important, the exact type of C&P exam question that can hurt your claim if your answer is incomplete, and the evidence you need in your file so the VA cannot look only at your medicated condition and ignore your underlying severity. I've been helping veterans navigate the system for years. I've seen the denial letters, I've read the examiner reports, and I've watched how one sentence in a C&P exam can change the direction of an entire claim. This rule did not survive, but the problem behind it still matters. And by the end of this video, you're going to know how to protect yourself without exaggerating, without guessing, and without letting your treatment hide the real impact of your disability. What the medication rule was. Let's start with what the VA actually tried to do. The regulation was called RIN 2900 AS49. It went into effect on February 17th, 2026. The core idea was this: when evaluating certain disabilities, the VA would not require examiners to estimate what your condition looked like without medication or treatment. Instead, if medication or treatment improved your functioning, the VA could rate you based on how you appeared while treated. That matters, because for many veterans, medication does not make the condition disappear. It only keeps the condition from completely taking over their life. Let me give you an example. You have a service-connected condition. Without medication, your symptoms are severe. Maybe you cannot sleep. Maybe you cannot stand long. Maybe your pain flares up badly. Maybe your anxiety or depression becomes harder to manage. Maybe your migraines are more frequent or more disabling. But with medication, you can function better. You are still limited. You are still dealing with the condition. But the medication helps you get through the day. The concern was this: if the VA only looked at how you function with medication, they could underestimate how severe your disability really is. Same condition, same service connection, same veteran, but now the rating could be based only on the treated version of the condition, not the underlying severity. That is the trap. And it gets worse, because the way this shows up most often is through C&P exams. The C&P exam trap. Here's how this can play out. You go to your C&P exam. The examiner asks you, "Is the medication helping?" You say, "Yes, because it is helping. That is why you are taking it." Then the examiner writes, "Veteran reports symptoms are controlled with medication," or "symptoms improved with treatment," or "functional impairment appears minimal while on medication." That report goes to the VA rater. The rater sees words like controlled, stable, improved, or minimal impairment. And now the full picture of your disability may be missing. You did not lie. You did not exaggerate. You did not do anything wrong. You simply answered an incomplete question with an incomplete answer. And that incomplete answer can create problems. Now, here is the part that makes this dangerous. A C&P examiner is not your treating doctor. They are not there to manage your long-term care. They are there to gather evidence for a rating decision. And if the examiner only documents how you are doing with medication, but never documents how severe your condition is without medication, the VA may not have the full picture. That is why veterans need to be careful. Not dishonest, not dramatic, just complete. Because the question is not only, does the medication help? The better question is, what does the medication help with? What does it not help with? And what would your condition look like without it? That is the difference between a complete record and a dangerous one. Why the VA reversed course? Ingram, Jones, and McCarroll. So why did the VA reverse course? Part of the answer is legal uncertainty. And one of the most important cases behind this issue is Ingram versus Collins, decided in 2025. Now, let me be very clear. Ingram was not a blanket rule for every condition and every medication. It involved musculoskeletal disabilities, conditions like back and ankle problems, where the rating criteria did not specifically account for medication. But the principle matters. The court addressed whether the VA could rely on the improvement caused by medication when the diagnostic code did not mention medication. And the court made an important point. If the rating criteria do not contemplate medication, VA generally cannot use the beneficial effects of medication to assign a lower rating. That idea also connects to earlier cases like Jones and McCarroll. In plain English, the fact that medication helps you does not automatically mean your disability is less severe. It may simply mean your treatment is helping manage a serious condition. Those are two different things, but this is condition specific. Some rating criteria do mention medication or treatment, others do not. That is why veterans need to be careful about broad statements like, VA can never consider medication. That is not accurate. The more accurate statement is this. When the diagnostic code does not contemplate medication, VA generally should not reduce the true severity of your disability just because medication helps mask the symptoms. That is why the February 2026 rule caused such serious concern. It appeared to move the VA toward rating veterans based on treated functioning, even where the law and prior cases had already raised serious concerns about doing that. So on February 27, 2026, 10 days after the rule went into effect, the VA rescinded it. Full reversal. But here is what you need to understand. Just because the rule was rescinded does not mean every examiner will automatically document your condition correctly. Some exams may still focus heavily on your current functioning while treated, and if the report does not capture your baseline severity, your record may still be incomplete. The masked symptom problem. This is where we get to the part that protects you. I call it the masked symptom problem. That is not the official legal phrase. The legal concept is the ameliorative effects of medication. That simply means the way medication or treatment can improve, reduce, or hide the symptoms of a disability. And here's why that matters. If your medication is helping you function, the VA needs to understand two things. First, what your condition looks like without treatment. Second, what limitations still remain even with treatment. Because medication does not always erase the disability. Sometimes it only keeps the worst symptoms from showing up on the surface. In plain English, your meds may be helping you survive the day. That does not mean your condition is gone, but here's the problem. The VA does not automatically know your baseline severity. Your doctor may write, patient is stable on medication, or symptoms controlled, or doing well with treatment. That may sound good medically, but from a VA rating standpoint, it can be incomplete because it does not explain what stable really means. Stable compared to what? Controlled how much? What happens if you miss medication? What symptoms are still present? What activities are still limited? What would your condition look like without treatment? That is what needs to be documented. Your medical evidence should show two things. 1, how severe your condition is without treatment. 2, how much the treatment helps and what limitations still remain. If your records only say patient is doing well on medication, the VA may not see the full disability picture. But if your records say patient continues to experience chronic pain, medication reduces symptoms but does not eliminate functional limitations. Without medication, pain increases significantly and limits standing, walking, sleeping, and daily activity, now the record is much stronger. Because now the VA cannot fairly pretend the condition is not serious just because medication helps manage it. They have to look at the underlying disability picture, not just the medicated snapshot. What to do right now? Here is your action plan. Step 1. Review your medical records. Look for language like symptoms controlled, stable on medication, doing well, improved with treatment. Those phrases are not bad by themselves, but they can be dangerous if the record does not also explain your baseline severity and remaining limitations. Step 2. Talk to your doctor. Ask them to document your condition in 2 states: how you are without medication or treatment, how you are with medication or treatment, and make sure they also document what problems still remain even when the medication helps. Step 3. If you have a CMP exam coming up, prepare your answer to the medication question. If the examiner asks, "Is the medication helping?" a complete answer sounds like this: "Yes, the medication helps reduce my symptoms, but it does not eliminate the condition. Without medication, my symptoms are worse in these specific ways. Even with medication, I still have these limitations." Then explain the specific limitations. Do not just say, "Yes, it helps." Say what it helps. Say what it does not help. Say what still limits you. Say what happens without it. That is not lying. That is not exaggerating. That is making sure the examiner documents the full disability picture, not just the medicated version of you sitting in the exam room. Step 4. If you have already been reduced or underrated because the VA relied only on your medicated condition, you may need to challenge that decision. Look at the diagnostic code. Look at whether that rating criteria mentions medication. Look at whether the VA considered only the beneficial effects of medication. And if the facts support it, raise the issue using the correct legal language: beneficial effects of medication, ameliorative effects, baseline severity, functional loss, and condition-specific rating criteria. Let's recap. The VA issued a medication-related rating rule on February 17, 2026. That rule created serious concern because it could have allowed the VA to rate many veterans based on how they functioned while treated, instead of fully considering the severity of the underlying condition. 10 days later, on February 27, 2026, the VA rescinded it. But the exam issue is still important because veterans are still being asked, "Does your medication help?" And too many veterans answer, "Yes." Then stop there. That is the risk. Your protection is not exaggeration. Your protection is documentation. You need your records to show baseline severity, the effect of treatment, and the limitations that remain even with treatment. Here is your challenge. In the next 48 hours, pull your most recent medical records. Look for any language that only describes your medicated or treated state. If you find it, schedule an appointment with your doctor and ask them to document the full picture. Not just stable on medication, but what happens without medication? What symptoms remain with medication? And how does this condition still affect daily life and work? That one step could be the difference between a complete record and a weak one. The VA is going to keep sending veterans letters that look like they were written by a robot lawyer. Do not let confusing language cause you to miss a deadline or misunderstand what the VA is really saying. Head over to veteranclaimsmadeeasy.com right now and use the free VA letter translator. You can take a confusing VA notification, run it through the tool, and get a plain English explanation of what it means. Know exactly where you stand before you take your next step. This video is the first installment of my new series, the 2026 VASRD Survival Kit. You need to keep a close eye on this playlist because rating rules, medical evidence, and exam language all matter. Next up, we are tackling the tinnitus deadline. The 10% standalone rating is expected to change under the new criteria, and if you are dealing with tinnitus, you need to understand what is happening before the rules shift. In the next video, I am going to show you what veterans need to know about tinnitus, the proposed changes, and how to protect yourself with accurate evidence before the criteria change. Get your letters translated at the website, and I'll see you in the next one. My goal is never to mislead, only to empower you with accurate, honest, and actionable information.